Welcome to Loud Little Ducky. Today we are going to go over Judge Azcarate's opinion letter to Amber Heard and Elaine. And this is one of the key points of error that Amber has filed for her appeal. And this is going to be the exact reason it's going to be shot down once again, just as it was prior to the trial. It's just not a winning argument. This opinion letter from Judge Azcarate was a motion filed on July 22nd, 2021 by Amber Heard's team. The overruling of requests denied was done on August 17th, 2021. And here we are in October, going to be November of 2022. And it's still, this motion is not going to be granted. This is in response to AH's lawyer, Elaine, trying to get a supplemental plea in bar, a plea that set out special reasons for which a trial cannot go ahead, lays out the grounds why a trial should not proceed, and the defendant wants case to be dismissed. Nope. These reasons that the UK case isn't equal to the US case. Son, enough evidence, which means substantially true or true enough, which is a 51% to 49% likelihood. Did they have enough proof from a resource to substantially say what they said? Well, they have a resource who was there, and there's pictures that have seemed to be altered. So the Sun can only go by what it's told and what it's shown, and what was shown to them and told to them, they thought it was true. They didn't have a reason to doubt that it wasn't true. So that's all that the UK case decided, is whether the Sun had a likelihood of being able to get away with this. And this is why defamation is usually not won, because usually, like, if you're going after media, well, the media wasn't physically there. So they don't actually know. But if they've been given something that showed them that this statement is true or could be true, they really can't be held liable for it. Parties in the UK were Depp versus the Sun and Dan Wootton for statement that said Depp was a wife beater. Amber, not a party, only a witness. Witnesses aren't held to the same standard of evidence requirements. Parties in the U.S. are Depp versus Heard for statements and headline that Amber wrote in the Washington Post. Both now have the same requirements of evidence because they are parties. They are not witnesses, they are parties to this litigation. So they have to turn over and do the same amount of stuff. In the UK, Amber didn't have to turn over a bunch of stuff because she wasn't a party. She could just hand over whatever she wanted. So it is a different case, different countries, different parties, heard by a judge in the UK and heard by a jury of 7 in the US. The Sun's article was published April 28th, 2018. The Sun was sued on June 1st, 2018. And then we have Amber's article being published in the Washington Post on December 18th, 2018. Amber was sued 3/1/19, so several months later after he sued the Sun. When he started suing the Sun, basically 6 months prior, Amber's article wasn't even published or written in the Washington Post. This article didn't exist. So how can this be the same case when the case in the US didn't even have anything until 6 months later? Make it make sense. The verdict came for the Depp versus the Sun and Dan Wooten on November 2nd, 2020. And then we have the verdict coming down for the US on June 1st, 2022. So those are all the dates that show these are not the same. Because if it was the same, all the dates would be the same, except for the verdict dates. Maybe the sued date, but the publication dates matter. Here we are going to talk about privity first. A close, direct, or successful relationship having a mutual interest or right refers to a connection or a bond between the cases. So it says here, accordingly, defendant and the Sun were not in privity. The defendant and the Sun were not mutual. Defendant did not persuasively present an applicable exception to the rule of mutuality. Thus, collateral estoppel is inappropriate in this manner, which we are going to learn what all those terms mean in this video. For privity to exist, Virginia law holds that a party must be so identical in interest with another that he represents the same legal right. Well, it is not identical. Not identical at all. While the Virginia Supreme Court did note in Lane that privity deals with a person's relationship to a subject matter of the case, the court has not expounded the constraints of such statement. Lane, 297 Virginia at 656. Consequently, this court looks at the legal rights and the interest of the parties and whether they are identical. Defendant argues she was in privity with the Sun because they both had the same interest in the case. However, for privity to exist, defendant's interest in the case must be so identical with the Sun's interest such that the Sun's representation of its interest is also a representation of defendant's legal right. The Sun's interests were based on whether the statements in the newspaper published were false. Defendant's interests relate to whether the statements she made or published were false. Although the claims are similar in the sense that they both relate to claims of abuse by the plaintiff, the statements being defended in the UK are inherently different than the statements published by the defendant. So it's saying, therefore, given Virginia's narrow construction of privity. So it just has to do with their relationship. That is the only common thing in this, but nothing else. Collateral estoppel. Accordingly, the following requirements must be met for the doctrine of collateral estoppel to apply. Number 1, the parties to the two proceedings must be the same. Well, that's not That does not get a check mark. That's crossed out, so we don't meet that standard. Number 2, the issue of fact sought to be litigated must have been actually litigated in the prior proceeding. It was not, because the statements did not exist at the time of being sued. Number 3, the issue of fact must have been essential to the prior judgment. And 4, prior proceeding must have resulted in a valid final judgment against the party against whom the doctrine is sought to be applied. None of those match here, because the facts for the UK trial are not the same as the facts for the US trial. So, the Washington Post statements have not been litigated. So, nope on that one. And the parties of the proceeding are not the same. So, no on that. And 4, it couldn't have been a final judgment against the party because Amber wasn't a party in that. So it's not a judgment against or for Amber. Amber was not a party. So she goes on to say, accordingly, defendant and the son were not in privity. Defendant and the son were not mutual. Defendant did not persuasively present an applicable exception to the general rule of mutuality. Thus, collateral estoppel is inappropriate in this manner. Is mutuality. Mutuality is the legal principle that provides that unless both parties to a contract are bound to perform, neither party is bound. So we have it discussing here, therefore Virginia upholds the mutuality requirement, thus limiting the influence of an initial adjudication by requiring that to be effective, the estoppel of the judgment must be mutual. Here, because defendant was not a party of the UK litigation, but seeks to preclude plaintiff, who was a party of the UK litigation, from re-litigating the issue of whether plaintiff abused defendant, non-mutual defensive collateral estoppel is sought. The subsequent civil case only required proof by a preponderance of evidence. The burden of the UK trial and the burden here are not so drastically different. While it is true the son held the burden of proof in the UK litigation, such burden was by a preponderance of evidence. This is the same burden applied here. So they are going to apply those things. It is an uphill battle. It's an uphill battle for Johnny. And here in the UK, he prevailed. Continuing with mutuality. This is not a matter of first impression. It is a matter of stare decisis, based on an abundance of binding case law holding mutuality is still a requirement in Virginia. Collateral estoppel is not appropriate here. However, even if an exception to mutuality applied, the court is not persuaded by the defendant's argument that plaintiff had a full and fair opportunity to litigate the UK action. Defendant was not a party in the UK action and was not treated as one. Because she was not a named defendant, she was not subject to the same discovery rules applicable to named parties. In fact, defendant could not have been a named defendant to the UK litigation because her alleged defamation statements were made after the UK action commenced. 6 months after. Attachment number 3 to defendant's reply brief includes a ruling from the UK judge regarding whether defendant should be ordered to make certain third-party disclosures. Defendant's reply memorandum, attachment 3, such third-party disclosures may be ordered only when the documents sought are likely to support the case of the applicant or adversely affect the case of the parties, and disclosure is necessary in order to dispose fairly of the claim. Senior Courts Act 1981, C-54, 34 CPR 31.17, thus to argue plaintiff fully and fairly participated in the UK trial action. Because defendant was an active participant providing evidence, 7 witness statements, and sitting for 4 days of live testimony, is encourageous, with the UK judge ruling regarding defendant's discovery obligations. Specifically, the judge refused the claimant's application for a third-party disclosure order against Ms. Heard. And that's in reply of the defendant's reply memorandum, attachment 3. Compare this standard to Virginia's discovery rules in Rule 4.1b1 of the Supreme Court of Virginia. So this is just res judicata / subject matter decided. Not subject matter to jurisdiction, as some of you may think. Not that. But res judicata, subject matter decided. A principle that when there is action, and the said action has reached a subsequent decision or judgment, the parties to the action cannot re-enter the action on the same basis since the subject matter has already been decided. Here, defendant claims res judicata is especially puzzling, Judge Azcarate says. At the time plaintiff initiated his suit against the Sun, the defendant hadn't even released her op-ed. Plaintiff's defamation claim in the UK was based on completely different statements than the present case. These specific statements uttered in the defamation case are incredibly important. See Carlisle versus Richmond. That is why this court, after defendant's demurrer, analyzed the 4 statements originally sued upon to determine if each of the statements met requirements for defamation. The statements from the Sun and from the defendant are not related in time. Several months passed between the publication of the 2 collective statements. They are not related in motivation. They are not released in space. The only relation is the origin, as both statements arose from the plaintiff's alleged abuse. However, it would be nonsensical to find that any statement relating to whether the plaintiff abused the defendant arose from the same transaction or occurrence, simply because they come from the same origin. Therefore, given the lack of privity and the separate occurrences in question, res judicata is inapplicable. So that is a good point, because she could go make another statement, and she could also get sued for that statement, and she couldn't say, we already went to court for defamation. You didn't go there for these statements. So, nope. Best thing to do is just quit running your mouth. You wouldn't have to worry about all these things. Comedy. No, not the funny haha. There's no performing. This is legal comedy, which is a jurisdictional principle of international law that holds that there must be mutual respects for the laws, institutions, and governments of other countries in the matter of jurisdiction over their own citizens. Virginia courts should not recognize a foreign decree which was falsely or fraudulently obtained, or one which is contrary to the morals or public policy of this state, or that would be prejudiced Virginia's own rights or the rights of its citizens. Importantly, the libel laws of Virginia are starkly different than those of England. The Declaration of Independence and the First Amendment of the United States Constitution represents major departures from the English common law with respect to freedom of speech and freedom of press. To hold that the two countries have similar libel laws is untenable. Not only are they substantive laws of the UK different than Virginia, but so too are the procedural laws. Continuing with comedy, noting Parliament allowed civil jury trials for libel actions in the past, but now it is usual for defamation actions to be tried by a judge alone. In Virginia, plaintiffs are entitled to a trial by jury if so demanded. However, such right is not available in the UK. Instead, in cases of libel, judgments are based on the reasoned decision of one judge, as opposed to a bald verdict of a jury. See defendant's reply in bar, attachment 330B. Of course, this court means no disrespect to the procedure adopted in the UK. It's just noting that it's different. Given the differences between Virginia and the UK regarding trials by jury and libel laws, the court is hesitant to apply preclusive effects to the UK finding, especially considering defendant was not a party in the UK suit and was not given the same discovery requirements in that suit. She keeps hounding that point over and over. Not a party, not the same discovery requirements, because that is very important. Thus, even under the factors of Hilton, the substantive and procedural difference between this case and the UK case do not warrant a granting of comedy. Defendant draws attention to plaintiff's more favorable burden of proof in the UK. Plaintiff did indeed have a more favorable burden of proof in the UK litigation, but that is not the only factor to be considered. That's Elaine's air quotes with saying he had his chance to tell his truth. There's no his truth. There's no her truth. There is the truth. And Elaine always liked to air quote it. Let's see. As previously mentioned, the procedural and the substantive laws regarding libel cases in the UK are vastly different than the laws in Virginia. Moreover, comedy is not a matter of obligation, but rather a matter of courtesy. See Am Online Incorporated, 261 Virginia at 361. To enforce the UK defamation judgment in this case would go against public policy. Therefore, comedy is inappropriate in the instance and does not serve to bar plaintiff from arguing his case before a jury in the Commonwealth. So, he gets to do it, according to Judge Azcarate. Uniform Foreign Countries Money Judgment Recognition Act, also known as the UFCMJRA, and that is an act to amend the civil practice law and rules in relationship to revising and clarifying the UFCMJRA. It is a recognizing to enforcing another country's judgment so that a party cannot try recovering in the states on the same suit determined in another country. Defendant is correct in her asserting that this court should enforce the UK court's judgment precluding plaintiff from recovering against the Sun for libel. So she agrees that if this was a case against Depp and the Sun for those same statements, he should not be allowed to do that, and she would respect that judgment in the UK. But that is not what the subject is in this case, and the son is not a party in this case, just like Amber was not a party in the UK. But she does agree, if that was the case, then of course. But plaintiff has not brought suit against the son in this case. Instead, plaintiff brought forth a different suit with different defendant based on different statements. Further, legal recognition of a judgment and preclusive recognition of a fact are not synonymous. Well, that's one of the first things that hasn't been synonymous in the Depp v. Heard case, because everything's synonymous to everything, seems like. And defendant has cited no Virginia case applying the UFCMJRA when the parties are not mutual. Consequently, the UFCMJRA is inapplicable here and does not mandate the dismissal of the plaintiff's case. So, nope, not getting a dismissal on this try. All of the things that you could throw, it seems like, to try. Let's try this. Maybe one of them will stick. But this one is chilling effect. In constitutional law, in the inhibition, or discouragement of the legitimate exercising of a constitutional right, especially one protected by their First Amendment to the U.S. Constitution, by the potential or threatened prosecution under or application of a law or sanction. Judge Azcarate goes to say, defendants claim that refusing recognition of the UK judgment in this case would set a dangerous precedent is unfounded. In fact, allegedly defamed parties are more likely to bring suit in England in general due their more favorable defamation laws. If anything, upholding English libel judgments in the United States would create the chilling effect and could create a dangerous precedent. Accordingly, this court is unpersuaded by the defendant's argument. This is them saying, if you do this, this is bad for everybody else. And it's going to be the judge's fault. It's going to be the jury's fault. It's going to be Depp's fault. Because nothing can be Amber's fault. And if she didn't want these dangerous and horrible precedents to be set, maybe she should have thought about that before opening her mouth and lying. It is ridiculous that they keep trying to say, oh, this is dangerous to do. Y'all shouldn't do this. No. It's upholding the law with legal authority. And there is plenty to back up the reasoning for it. And you just accusing everything and everybody doesn't help. The fact that you threw out all these different things because you didn't think just one would work. You're like, let's just put everything out there. It's kind of the way her bullet points and key assignment of errors is too. Like, just 16 of them. It's ridiculous. And Lord help us if Daryl Brooks or somebody decides to appeal every single objection that he's ever made. And Lord, it's going to take a year just to count all the objections. But it's not going to work. This is a legitimate ruling. And there is nothing wrong with the decision that has been made. And I do think that this argument should be unpersuaded. And it's just laughable at times. In conclusion, for the foregoing reasons, defendant's supplemental plea in bar is overruled. Regarding plaintiff's request for sanctions, such request is denied. While defendant's supplemental plea in bar was misguided and only thinly supported by pre-existing law, it is not sanctionable. However, based on this opinion, paragraph 13 of defendant's grounds of defense is hereby stricken as moot. An order is attached. Sincerely, Penny Azcarate, Chief Judge of Fairfax County Circuit Court. So she said, we are not doing this. And I think because she detailed and explained her reasoning behind denying each and every argument and why it doesn't pertain in this instant, I think the appellate courts are going to see that and be like, yep, this is not going to be a winning part in an appeal. I don't know why she keeps trying. It didn't work in the beginning to try to get it to go away. It's not going to work in the end. But if you like more videos like this, hit that like button, subscribe, and I will see you in the next video. Bye!